Today, we're going to talk about how to build a blueprint to actually control your future. And there's different components that make this up. Part of it is protecting your wealth, but as important is protecting your wishes and your legacy as you move through retirement. Today, we're going to talk about all of this. So, what's the trap? There's an ad on TV right now that where a commentator asks, "How's your retirement planning going?" And the person responds, ignoring it and hoping for the best. And unfortunately, that's what I think a lot of people do. They move into retirement and they figure good things will happen, and they don't worry about what could happen if they don't plan for the future. One of my favorite movies is Back to the Future. And in the final scene of the third movie, uh, Doc comes back from the past, and Jennifer asks a question, what happens to your future? And what Doc says is that no one's future has been written yet. No one's has. Your future is whatever you make it, so let's make it a good one. And what this really boils down to, hope is not a strategy of planning for the future. Hope is great, but having an architecture to actually under support the decisions you make and create a future you want is the way to go. So, what's the default problem with not having a plan? Well, many people go through two phases. One is disability. As we get older, we're living much longer. We've done webinars on long term care planning, and most people will require some form of long term planning before they pass away. And the problem with it is if you don't have basic legal documents in place to protect your wishes on financial and medical decisions, well, the alternative is guardianship. And this is an expensive process and it's court centered. It's something to be avoided. And for many people, after they pass away, if they haven't planned on transferring assets to the next generation through legal documents, well, the result is you die with a state imposed will. The state of Texas has a will for each one of us if we don't have our own. It's known as intestacy. And unfortunately, it means assets may end up going to people that you would prefer not to have them go to. So, in our practice, there's actually two components to building a structural engineering team. On the financial side, that's what we do at Senior Resource Center. We help our clients understand financially where they are today, where they'll be into the future, and we help build models to support this. We also partner with elder law attorneys. Happens to be one in our building, Andrew Friedman, who is an excellent elder law attorney. He makes sure that our clients have the right legal documents to protect their wishes. Tara, why don't you take it?
Okay. All right. So there's two phases. You have legal documents you want during your life that'll affect you choices during your life, and then ones after death. So what you need while you're living is a financial power of attorney, a medical power of attorney, a living will, a HIPAA, and possibly a guardian designation. And then the documents you'll need that will go into effect after death would be a will, a trust, and then any beneficiary designations that you put on any assets when you were living. So, phase one is your powers of attorney. There's two types. You have your financial power of attorney and your medical power of attorney. The financial power of attorney gives someone the ability to make financial decisions for you, or to, let's say, access your bank accounts or find out what's going on with your life insurance or, say, any kind of financial products. And that gives them the authority to do that. The second one is a medical power of attorney. Medical power of attorney is what it's obviously for, to make medical decisions for you. Because only a spouse can make any medical decisions for you. Without one, anyone else, including your children, cannot make medical decisions for you. And then it falls on the physicians. So you definitely want to have one of those. And those two things are good while you're alive. The second thing you'll have is a living will. And this is also important because it's telling the people who are around you, if something happens, here's what I want. Do I want, what do I want if I have a terminal illness? What do I want? Do I want a DNR? Do I want to be kept alive for longer? It gives a direction to not only your medical power of attorney, but to the physicians that are providing that care. So that's another one that's real important while you're of sound mind to make a decision on, and then give that not only to the people who are you're appointing, but also to your physicians. Okay, so in phase two, this only goes into effect when you die. And a will basically names an executor to tell everyone what did you want, to give away, how you wanted things paid, how you wanted things given to others or to who it would go to. But the problem with that, or the challenge, is you have to go through probate, and probate means going in front of a judge. It means hiring an attorney, and there are ways to avoid probate. Probate's not bad in Texas, but if you want to avoid that extra step and that extra cost for your family, there are other things that you can do.
So Tara brought up probate, and as she mentioned, we want to avoid it. And let's talk about the reasons why probate may not be a desirable thing to go through. Uh, the first is your assets are frozen. If you die and have a will, until that will has been processed by a court, and there's a waiting period to have your will reviewed by a court, approved, and have an executor appointed. During that time period, your assets are frozen. But you and I both know that life goes on. There are bills that have to be paid, expenses. If you have a home, obviously somebody's got to continue to make payments for utilities, for taxes, things like that. And assets are frozen until a probate judge appoints an executor, approves the will, and allows the executor to begin managing assets. A second major problem with probate, it's a public forum. And there's two sides to this. First, when you use a will to pass assets after you die, those assets are reported to a county probate court, and anyone can see how much you gave and to whom. So it allows unscrupulous people to target people that have just inherited substantial amounts of money, to target them for scams and for theft. The second problem, wills can be disputed. Just because you have a will saying, I want these assets to go to these kids, it doesn't mean that another child, maybe a black sheep in the family, can't come forward and make claim to a portion or all of your assets. So, once again, being in a public forum, not a good place to be. And the third is expense. Uh, Probate judges in Texas have become lazy over the last 10 years. Today, they require that your executor bring in an attorney to the court for court efficiency. What's the problem with that? Your kids are going to spend $2, 3, $4,000 probating your assets, passing assets, and transferring them to the next generation. And there's no reason to go through this. So, what are two ways to avoid probate? The first is beneficiary designations. And in our practice, we find this to be the most simple and the least expensive way to transfer assets after someone dies. So, what is a beneficiary designation? You're naming somebody who will receive your assets after you pass away. And you can put a beneficiary designation on literally all of your assets. If you have a home, there's a special warranty deed called a ladybird deed that allows you to maintain all of your current privileges in living, and the ability to sell your home, to lease it out if you wanted to keep your senior exemption. But more importantly, it names one or more beneficiaries after you die. Well, if you've put a beneficiary on your home, there is no probate. Your kids go to county records, they file a letter and a death certificate with county records, and guess what? The home title changes to whoever you've named. What about an automobile? If you have a vehicle, the state of Texas has what's called a beneficiary title. You can name someone as the future beneficiary of your vehicle. If you have that, no reason to go through probate. Uh, while you're alive, if you want to, you could sell the car without passing it to that person. You could sell it if you want, but if you die owning it, the transfer occurs without going through probate. Uh, so there's many reasons for using beneficiary designations. You can put them on all financial assets, whether you've got a checking account or a savings account. Banks have what's called a payable on death or a transfer on death notification, where your asset moves to whoever you've named. If you have other financial accounts, say a brokerage account, an IRA, an annuity, a life insurance policy, all of these can have beneficiary designations on them. And once again, by naming it, assets that are named, that have a named beneficiary, do not get processed under a will. They automatically transfer. Now, the second way to avoid probate is a little bit more expensive and more complex. It's setting up a trust. And Tara and I are not attorneys. There are many, many different kinds of trusts. Ones that'll take care of a disabled child after you pass away. Or you may have heard of a living trust, where your assets are in the living trust, and after you die, a follow on successor trustee distributes your assets. We don't want to get into the details of trusts, but if you have a complex estate, if you have property in multiple locations, maybe in multiple counties, well, each of those would have to be probated separately, and a trust can avoid all of that. A trust is nothing more than a legal entity, a legal box that doesn't die when you do, and you have to title assets into the trust. Just setting up a trust, that's the first step, but then you have to title the assets into the trust that will be governed by the trust. And the trust is a set of rules. It says after Bill passes away, the assets in the trust will be distributed according to this formula. What's a good advantage to a trust? It's a private transaction, as are beneficiary designations. So people can't see who you're giving assets to and how much. So, Tara, why don't you summarize for us?
Okay, so basically, here's the lowdown, and this is these just basic documents everybody needs. Is these aren't old people documents; these are everybody documents. So, first, a financial power of attorney. It can trigger an incapacity or capacity. There's two lines on the power of attorney, and you can scratch off at my incapacity or inability to make decisions. Maybe you just are tired, and maybe your mind is going, and you want your son or daughter to help you now versus when a physician would say you're incapable of doing that. So you have that choice. That controls your property and money. But if you don't have it, they may have to create a guardianship for you, which can be very expensive and frustrating for the family member who has to do that. Medical power of attorney, that happens at incapacity. Those are your healthcare choices. Again, state guardianship. Your living will, that's making decisions about how you want your medical decisions to be controlled or what that looks like. And that's kind of end of care life. And so that eliminates family disputes and doctors having to decide your care. And then you have your last will and testament. That doesn't go in effect until death. That's what probates your assets. If you don't have a will, then the state has to step in. We don't want to do that. And then finally, a trust. This is optional. But again, you sign it while you're living and making decisions, but it goes into effect at your death, and it protects the assets inside the trust. If you don't have that, then you do have to go through probate. So here's kind of the groundwork that we manage or believe in at SRC Texas. And that first thing is your foundation. That's the most important. Do you have enough money to get through retirement? What kind of income can we create? What kind of protections do you have on your assets? How can we save more on your taxes? Then you have your walls, which is your living documents, like we're talking about financial and medical power of attorneys. Then your roof and towers are things you need at end of life, which is a trust, a will, beneficiary designations that pass things on to the next generation. So in order to solve that or to figure that out, we used our retirement analyzer software, which puts in your expenses and your assets and looks at Where's your red line? Where are you going to run out of money in retirement? Or maybe you're not and you're set, but it just makes you feel good. So you can come in, we can do this plan for you, and then annually we can tweak the plan. Maybe you sold a house, maybe you invested in something and spent a little more money, and we can reevaluate and see where you are. And it's a real important thing to do instead of just, like we talked in the beginning, ignoring things. So, with that, we have a one time fee to put together that retirement plan. And then once it's done, it's done. We can revisit it. If you want to meet with our partner attorney, Andy Friedman, he can help you with all the legal documents. And then, every, half year, we can reevaluate and see how things are going with your retirement. So, going forward, give us a call. We'd love to talk to you about how to make your retirement safe and secure. We also have our book, More Money for Retirement, that's available as a PDF, downloadable book on our website, srctexas.com. And we would love to hear you and help you. So give us a call. You can talk to myself, Bill, or our other business partner, Stacy. So with that, we'll say goodbye and we'll see you next time for our next session. Have a great week. Bye bye.